Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular video I'd like to talk about what is called the petty offense exception. Now usually when you try to adjust status from inside the U.S. or you do consulate processing from outside the U.S., it is when you are trying to come into the United States ultimately to become a lawful permanent resident. Now, the way it would work is if you committed a crime, generally speaking, you need to look at the criminal statutes and you need to look at the inadmissibility statutes under immigration law to see if a waiver is possible or if a waiver is needed. And essentially what the waiver is when you submit the brief and the declarations and affidavits, and you basically say, I know I committed the crime, I'm sorry, please let me in, okay? And you meet the requirements by showing hardship and so forth to the qualifying relative. Well, waivers are not easy to obtain. So if there's a way around doing the waiver where you still committed a crime, but you don't have to do the waiver and are still admissible to the United States, then that is the path you want to take. And the way that this could happen is if you fall under the petty offense exception, then yes, it is a crime that you've committed, but you don't need a waiver and they can't stop you or claim that you're not admissible because of that particular crime. Okay, more on the coming videos.